Well, welcome to this panel discussion of James R. Copland's book, The Unelected, How an Unaccountable Elite is Governing America. A book, I think, with rare insight into why more and more people report dissatisfaction with democracy, with the elite's underrepresentation of the majority, with the under-accountability of those who govern us, with the unfairness of regulations, with weak corporate accountability to shareholders, with the propensity to settle issues through litigation rather than legislation, with the collapse of the rule of law, particularly pertinent in recent times, and with creeping censorship and cancel culture. My name is Bruce Oliver Newsome. I lecture in the Political Science Department at the University of San Diego, and it is my honor to introduce the distinguished members of this panel. The order in which I'm going to do this will purely be arbitrary, alphabetical by first names. So the first person to welcome is Professor Amy Wax. Amy is the Robert Mundheim Professor of Law at the University of Pennsylvania, one of my alma maters. She's a Doctor of Medicine too, as well as a Juris Doctor, and specializes in biomedical, economic and welfare issues, as well as liberal theory. As an assistant to the Solicitor General at the US Department of Justice in the late 1980s and early 1990s, Amy argued 15 cases before the United States Supreme Court. So welcome, Amy.
Thank you. I'm glad to be here.
Thank you. Next is Andrew Tettenborn. He is Chair in Law at Swansea University in Wales and a fellow member of the Free Speech Union. In fact, he's on the advisory board of the Free Speech Union. Andrew specializes in private law, commercial law, contract law, and maritime law generally. And I've asked him to make parallels with the British case with this book, which focuses primarily on America. So Andrew, thank you for being here. Welcome.
My pleasure.
And then John Yoo. Professor John Yoo is the Emanuel S. Heller Professor of Law at the University of California at Berkeley, where I was once faculty myself before I moved to San Diego. He is also a visiting scholar at the American Enterprise Institute and a visiting fellow at the Hoover Institution. John served in all three branches of government. He was an official in the US Department of Justice, where he worked on national security and terrorism issues. He served as general counsel of the US Senate Judiciary Committee, and he was a law clerk for Supreme Court Justice Clarence Thomas and federal appeals judge Lawrence Silberman. Welcome, John.
Thanks. Great to be here.
Nice to see you all. So before we start statements, I'm just going to state for the record, none of us has a stake in this book or the publisher or the book's author. Indeed, none of us know the author. We just find the book's argument worthy of discussion. So let's just make a note of what the book promises. So just editing briefly from the book's cover, it promises to explain how, quote, the unelected control much of the government apparatus that affects our lives. Administrative agencies churn out thousands of new regulations a year. Courts have enabled these agencies to expand their powers beyond those authorized by law. The proliferation of rules and the severity of sanctions give enormous discretion to unelected enforcement agents, upending the rule of law. Private attorneys regulate vast swathes of conduct through lawsuits based upon legal theories never voted upon by the people's elected representatives. And finally, state and local officials have increasingly pursued agendas to dictate the terms of national commerce, end quote. So that's what the book promises. So to discuss the book, I've asked each panelist to give an opening statement in turn, and then we will discuss the book collectively. So we're going to start with the two other Americans on this panel. We're going to go Amy, John, Andrew. So Amy will be first to go. Amy, please go. Thank you.
Yes, I only have a short time here, so I will try very hard to be brief. I'm delighted to join this panel to discuss James Copland's fine book, The Unelected. And I want to begin with three very brief anecdotes that illustrate the points, the observations I want to make. So here goes. First, many years ago, there was a proposal in the United States for something called Hillary Care. And I was invited to participate in the discussions. This was to create a national health service that many years ago under Clinton. And I listened for a couple of days to the discussion, all of the very august and distinguished experts who had come to talk about it. And when I was finally asked my opinion, I said two things. I said, after listening to all of this, I would recommend that you prioritize simplicity and transparency so that the good citizens of the United States will understand what this plan is all about. I also recommended that they de-emphasize equality, which they were obsessed with, in favor of minimal adequacy of the plans. My second incident is something that happened here at Penn. I was asked a number of years ago to be on a committee to review and oversee research university-wide. And at the very first meeting, a number of new positions, administrative positions, were proposed, hiring people with new and nebulous responsibilities at great cost. And both as a faculty member and as a Penn parent at that time, my comment was, why are we hiring new people? We should be thinking about ways to shed people from this bureaucracy. The response I got, of course, was, who let this person in? The third anecdote relates to a talk I heard a number of years ago at Penn by one distinguished Cass Sunstein, and this was during his tenure at OIRA, the Office of Information and Regulatory Administration, under Obama, and he focused a lot on the decision to mandate rear cameras in all passenger vehicles, the federal government mandate, something which was designed to prevent at most a couple of dozen child deaths, mostly run over by their own parents in their own driveways, at great cost, additional cost for each vehicle. And afterward, I went up to him and said, you know, this seems not worth the candle. You are transferring individual responsibility to the government without any, as far as I'm concerned, real justification. And his response to me was, you are a benighted reactionary, or something to that effect. Now, before I go further into the significance of these anecdotes, I do want to make a general comment about this book and what I think makes it particularly worthwhile and original in its contribution to a pretty large literature on the excesses of the administrative state. Not only does Copland offer a wealth of documentation on the government bureaucracy, but he also, I think, quite smartly ties these developments into another trend, which is the aggressive increase in the number of types and lawsuits and the roots of that increase in the reforms and relaxation of procedural requirements, the expansion of the common law, and of statutory causes of action. And as someone who in the past has taught procedure, I found this very illuminating and very enlightening. Now, what do these developments, the expansion of the administrative state and the litigation state, have in common? I think a vast increase in the controls of unelected elites over the rest of us. And I would emphasize here the elite part of it. The symbolic analysts, the judges, the lawyers, the bureaucrats. They not only represent a small number of Americans, but they also represent, and I think Copland doesn't quite bring this out enough, a particular ideology, which is a shared progressive ideology of the so-called elite educated class. Now, what do I identify as the key components and commitments of this ideology? And, you know, Copland really, this resonates to what he says. There are four. First, the desire and push to complexify, to make things more obscure, more complicated, rather than more transparent and simple, not accessible and understandable to ordinary people, but something that only experts can really comprehend. And Copland talks about this. This is a very self-aggrandizing move, obviously. Second, a commitment to growth in the elite domains, bigger government, more bureaucracy, greater power for courts, judges, and lawyers. That should be obvious. Third, the principle of what I call transfer, of shifting responsibility from individuals, from private entities, from the citizenry to the government at all levels and in all ways. And of course, to express, to respond to all sorts of dissatisfactions and perceived problems, and to see the government as the solution to them, to address what the philosopher Michael Oakeshott calls the felt needs of society, right, whether great or small. And finally, the principles of globalization or universalization, using lawsuits and public interest litigation to leverage local power and local problem solving into big, intrusive, widespread solutions. And Copland does talk about that, but the idea is, the ideology is, if it's a problem somewhere, then it's a problem everywhere. If there's a solution somewhere, that solution has to be applied everywhere. Now, it's unclear to me from reading this book whether Copland thinks that these features are just built into the system. They're systemic, they're structural, to use some currently fashionable terms, ineluctable and deep features of modernity itself. And there are things that he says that implies that we wouldn't want to dismantle the system entirely or even mostly, because it goes along with our increasingly intricate and interdependent society. And at the end, in his last chapter, he does propose some fixes. They are mainly modest fixes and procedural fixes, but he doesn't really disrupt the basic template. Now, I can't say I entirely share this take. Rather, I think that the trends Copland documents, which will be very difficult to extirpate, are far from inevitable and unavoidable, because I think at the end of the day, they are not entirely, but they are significantly ideologically driven. They are driven into what our elites are overwhelmingly indoctrinated into and enthusiastically embrace, which is a philosophy that says expand, extend government, see it as the solution to all problems, look at ways to transfer power and responsibility from individuals and towards the larger whole. These are the fundamental ideological commitments that are shared by those who are in control. And what that means, and I think my anecdotes illustrate it, is that politics matters. Who's in control? The people who are in control, their outlook, their attitudes, their basic ideas about the proper relationship between government and the people really matter. So to me, the fixes are not so much a matter of technical tinkering with the machinery and procedural rules, although those are not unimportant. Rather, they follow from the fundamentals of politics and philosophical commitments. So going back to my anecdotes, the common theme is simple and perhaps naive challenges to certain basic assumptions taken for granted by those in charge. And of course, the reactions I got were extremely negative. I was not supposed to question the basic assumptions, perplexed, startled, astonished, shocked at the questioning itself. But I think that is what we need to do. We need to find people who do question the basic assumptions. And that brings me to my last comment. There's another critical factor here, seemingly unrelated to the topic of this book, but quite pertinent: how elites are currently educated. More specifically, how schools, universities, professional and law schools promote and valorize and moralize all the progressive preferences and assumptions that currently dominate the system. The question to me is, how can we make the desire for smaller government great again? How can we get people to see that litigation in the public interest is often not in the public interest, that overregulation and hyperregulation has grievous costs that often outweigh benefits, and that government should often cut back or just stay out of areas best left to individual initiative? How do we foster the ideas, habits, and character traits and ways of thinking that go with these reversals and are necessary to make them work? Obviously, we cannot go back the whole way. I understand that. But I think we can go back a lot further than even someone like James Copland believes. And ultimately, these are the most important challenges and profound questions that I think lie at the heart of this book. Thank you.
Amy, thank you. Fantastic. Without any delay, John, over to you.
Thanks, Bruce. Thanks for inviting me. Thanks to the University of San Diego, and thanks to my fellow panelists. This is, as Bruce said, don't know the author, have nothing at stake really about whether the book succeeds or not, but it's a great opportunity to talk about the ideas it raises. I have a lot of the same ultimate issues that Amy does, and maybe this is a difference between being an academic and being in a think tank. The book's recommendations for reform are a little bit small bore and work within the doctrines established by the institutions he criticizes. And so maybe think tankers are supposed to be much more practical and look to achievable results. But I agree very much with Amy that the problems are much broader. And I think it's incumbent on us to try to have a bigger, more sweeping diagnosis of the problem, and then also think of more radical solutions. Maybe chart something farther that think tankers can then work towards. So that's my main disappointment with the book, but my also main agreement. I agree with Amy and the book about the diagnoses of the problems. Right? I mean, I think this is very simple. Copland just says, right, here is the lawmaking system that the founders set up. Right? It's very simple. Congress passes laws, presidents execute them, and the courts adjudicate disputes. And he says, compare it to the world we have today, the welfare state and the litigation state, where Congress has delegated massive authority to the agencies, independent agencies relatively free from presidential control, implement regulations, interpret those laws, and the courts are deferential. He spends a lot of time writing about a fairly technical area of law called the non-delegation doctrine, which is probably only of love to me and Amy about. But the non-delegation kind of expresses all of that in all these problems in one doctrine. Congress tells agencies to regulate all air and water in America in the public interest. Agencies then sit down and pass regulations like the one Amy was talking about just a second ago. Do cars have to have automatic cameras in the back that go on when you reverse? Courts have said repeatedly they will not review the substance of these regulations. They just want to make sure that agencies follow the process they're supposed to in something called the Administrative Procedure Act. And then there's a whole second problem, which Copland points to, which is the influence of litigation, primarily class actions and then consent decrees, which he says represent another kind of lawmaking that's just completely outside the founders' original vision. But I also share with Amy her point that we can't throw everything out and say, let's go back to the 18th century. The world is different. I would actually think the founders would probably be surprised if they were to see the same lawmaking system in place now, given how different the country is. And the book reflects that. The book does say here and there have been these changes with commerce, with technology. He says that even the American people don't seem to want to govern themselves. If a lot of the book starts out and ends with the COVID pandemic. And so you could say, well, would the American people have rather had Donald Trump or Dr. Fauci in charge of the response? Sadly, I think the majority of American people say Dr. Fauci, the unaccountable bureaucrat. They would trust him probably, as reflected in the elections, much more than the elected president that was chosen through our democratic system. You could say, would the American people rather have Dr. Fauci in charge or Congress in charge? Probably the polls would reflect the American people like having unaccountable bureaucrats in charge of things. Right? If you look at polling right now, the least democratic branch of our government, the Supreme Court and the judiciary, is the most favored by the American people. And the most democratic branch of our government, Congress, is held in the lowest esteem of all institutions in America, other than the truly worst institution, the mass media. Right? So that gives you a sense of, if the American people were put to a vote today about whether they want to govern themselves in the way Copland wants, or the way the founders wanted, they don't seem to want the job anymore. So what do we do about this? So conservatives or critics, I think, share a lot of Copland's diagnoses. The thing that's missing to me is an overall theme. And I think this is what I would add on top of Amy's comments just now, is what is really the main problem? So Amy said it's the elites, and I agree with that. It's sort of cultural almost. The other problem I would point to is something broader than what Copland's pointing to, because, and this is why I think that there's the problem of a missing overall theme, is because some of the remedies he calls for are somewhat in conflict with his diagnoses. So if you look at some of his criticisms, he talks about the judiciary's taken on too much power. And he talks about state governors, right, taking on, and attorney generals in particular, taking on too much power to interfere with the national markets, basically. But at the same time, his reforms are, we want a much more activist judiciary, right, to strike down regulations. And one of his other recommendations is we need a reinvigorated federalism. Right? The remedies and the diagnoses don't fit, because I think what he's giving voice to is our instincts that conservatives have when they read and they see about what's happened in the world. But I think you got to take a step back and look at the bigger problem. So I agree with one is Amy's distrust, which I share, of elites, elite education. This sort of, I mean, I think Cass is a great guy, but Cass, since he sort of exemplifies elitism, right? The idea of cost-benefit analysis done by those trained and taught are superior in result to democratic decision-making. Right? Cass is sort of the Woodrow Wilson of the 21st century in that respect. I would say, actually, the problem is broader, and I would say Cass and Woodrow Wilson sort of represents to me the last gasp of Wilsonianism. The Wilsonianism dominated the 20th century, not just internationally, but domestically. This idea of technocratic, insulated power and government decision-making controlled by an elite education system. Amy's quite right about that, behind it. It doesn't work anymore. And the reason it doesn't work, it seems to me, is because that whole system was built on the idea of the Industrial Revolution and a nationalized economy. Right? This is progressivism and the New Deal state were a reaction to a kind of economy that the Constitution didn't really anticipate. Right? Nationalized markets, transportation, communications at the level we had in the 20th century, mass production. You can look, and the book just starts at the end to recognize the 21st century is different. We have an information and communications revolution where the most valuable items in our economy have no tangible physical existence, right? Facebook doesn't physically exist anywhere. The product is just electrons, right? Google doesn't exist physically, and we're just not offering a product. It's all intangible. So that's one enormous change. And then the other enormous change, Amy mentioned this, was globalization, right? Globalization of the economy, globalization of problems. Why would we think that the New Deal state would work well handling those problems of the 21st century, those economic and technological changes, any more than we would think the 18th century Constitution and its public system would handle the Industrial Revolution and nationalization? And so I think the way I would describe Amy's follow-on diagnosis of Copland's book is that to me, it's almost as if the New Deal state feels power slipping away, and so it grabs harder. That's why we see things like these bizarre efforts to use prosecutorial discretion the way it's used, or to see these guidance letters issued by the education department, which I'm sure are going to return shortly, about campus discipline or affirmative action and so on. The more the system grabs, it's a response to, I think, an insecurity that government power, the ability to control this new world, is slipping away. So let me just end with, well, then what is the real solution? It seems to me radical decentralization has got to be part of the answer, that the nation state of the welfare, the New Deal, can't really regulate, as we see today, Facebook, Google, right there, this new information world. So one level, you would need radical decentralization. Maybe Governor DeSantis in Florida is maybe the future, passing a law saying, I'm going to punish Facebook and Google for deplatforming people if the national, and then maybe a state would be more effective at that. At the same time, I think you would want nation states to narrow their duties, to focus on national security, borders, pandemic response, things that are occurring and attacking the country from abroad might be a better way to focus our the national government's attentions, and that local decentralized governments are better for handling a lot more of the problems, because that's maybe the level of government that kind of fits this kind of world. And then the nation state has to represent us at the level of international cooperation, because that's the only way to handle some of these problems too. But I agree with Amy. I don't want to see international, supranational governments control. I think Britain, I'm very curious to hear what Andrew's going to say next. I think Britain shows, and Brexit shows, that the European Union, look, would you rather have lived in Great Britain or the European Union during the response to the pandemic, right? I think that the nation state, the supranational government approach to these problems is not going to work. Instead, you're going to need stronger nation states to cooperate effectively. And then the last thing I'll throw out there is, I think, ironically, you need stronger libertarian rights. And so in this last respect, I dissent from Copland. I don't necessarily think that too many lawyers and judges is the problem. So I just want to tell a last anecdote, because Amy told lots of great anecdotes. I don't have great anecdotes. I have a small anecdote. So I got to take the last class ever taught by Daniel Bell, the great sociologist. And it was a class about American exceptionalism, what makes America different. And one thing he observed was America is different in the number of lawyers we have and litigation. And so on my way to law school, I said, well, that seems like a big problem, right? Japan has no lawyers, right? Asia has very few lawyers. Are lawyers choking off American innovation in the economy? And I was totally shocked. Bell said, actually, all this litigation, our lawyers are a sign of why America will, and this is in the 80s. So he actually thought he was quite prescient. He said, this is a sign of why America will do so well in the 21st century, because with all those lawyers and litigation, you are also going to have better rules about intellectual property, about information. And he said it has a lot of costs, which are well documented in the book, about excess litigation. But he said, actually, you have all those lawyers and litigation because Americans believe in their individual rights and they're willing to press them forward. And so the last thing I would say is, maybe also part of the solution is a stronger return to libertarianism. But the only way really to protect that libertarianism is by strengthening one of the institutions that Copland doesn't like, which is plaintiffs' litigation, essentially, and class actions. So, thanks a lot for giving me the opportunity to discuss the book. I really enjoyed it, and I really enjoyed participating on this panel. Look forward to Andrew's comments.
Well, thank you, John. Thank you, John. Yeah, that's a great segue. So you mentioned Andrew's going to talk about Britain. I'm going to thank my fellow Americans and look forward to my fellow Brit, Andrew. I can do that because I'm a dual citizen. So yes, as I said earlier, I specifically asked Andrew to draw parallels with the British case, because James Copland's book is rightly focused on the American case, and there's lots of parallels with the British case. The administrative state and also the sort of what would you call the rebellion of the populace against the tyranny of the unelected, we might put it like that, through the Brexit vote and other exercises of popular will. So I think there's lots of parallels here, and yes, I think we're all looking forward to how Andrew draws those parallels. So Andrew, over to you.
Right, well, I'm delighted again to be on this panel, and like the rest of you, I don't have a dog in this fight, which means I can say exactly what I like. I very much enjoyed this book because although it was written about the legal system of the United States, where my knowledge, I'm afraid, is not as good as it ought to be, what I kept on noticing was a great many parallels between what I read here and what I saw happening in my own country. Okay, we don't have the great American federal agencies making life impossible for us, but we have equivalent organizations that make life very difficult and which sideline what any ordinary person might think was the sensible way of doing things. Now, the threats to democracy here, of course, are very different in institution from those in the States, but have much the same effect. And as was mentioned by John, we've just escaped the clutches of one of them, which was the EU. Now, the EU had all the evils of the bloated New Deal American state, riding in on the basis of the Commerce Clause and persuading the Supreme Court to say that the Commerce Clause effectively allowed the federal legislature to tell anybody to do whether they were in the middle of Idaho or Ohio, because somebody somewhere involved in interstate commerce might come across them. The European Union did very much the same thing, billed originally as essentially just a commerce clause, a free trade organization. It then morphed into an organization with pretensions as to social rights of all kinds. It is now, for example, we're out, thank God, but earlier this year, it started telling the Poles and the Romanians how they're to appoint their individual judges at a state level. Why? Oh, well, of course, you see, those judges might find themselves enforcing EU law. And the EU believes in the rule of law, and we need to be able to guarantee that EU law will be properly enforced, etc., etc. The Court of Justice of the European Union was like the most enthusiastic Supreme Court after the great flip of the 1930s. Now, we've got out of that, thank heavens, though we've kept quite a lot of its legislation, like, for example, its laws on data protection, which is a great mistake. I'm sort of hated in my university for saying that, but then I'm hated in my university for just about everything, so don't worry about that. The trouble is, of course, there is another institution which you don't have in the United States, which is catching us all even more now. That's the European Convention on Human Rights. Now, the trouble with the European Convention on Human Rights is that it's suffering from exactly the same mission creep as the European Union earlier suffered from. The European Convention on Human Rights now tells us pretty clearly the balance between free speech and rights of privacy. It's essentially rewriting most of our abortion law. Only yesterday, the European Convention on Human Rights started rewriting the criminal law, in particular, what had to be done on the rape shield. It's now essentially launched a takeover bid to make sure that we all do the right thing according to the elite. In a sense, it's turning into a sort of reproduction of the situation you had in Lochner in New York. Whenever you try and do anything which is different from what the elite think, the European Convention on Human Rights, and in particular the right to a private life, which now means anything that makes anybody's life nicer, as far as I can see, is being I can give you chapter and verse if anyone's interested. But that is, it's on the back of that that the European Convention is actually making life extremely difficult for us. We also, of course, have very vague laws. And this is particularly noticeable, to tell you the truth, as regards our freedom of speech. Because obviously we don't have the First Amendment. What we do have is, for example, a law that says that you mustn't use a telecommunications system to say anything that is grossly offensive. Now, that originally came in to deal with people who made nuisance phone calls. But then somebody, you can see the sort of light bulb moment. Oh, telecommunications system, that's the internet. Would be, it's not, we can now make it a criminal offense to be rude to anybody on the internet. And it's been used. For example, I don't know if it reached the United States, but there was a well-known blogger in Scotland who taught his dog to do a Nazi salute whenever he said Heil Hitler. Now, okay, that's not everybody's cup of tea as a sense of humor, but an extremely humorless Scottish sheriff who presumably breakfasted off cold porridge and a sermon every morning decided, oh yes, that's a criminal offense. It's actually quite a serious criminal offense. I'm not going to take into account any of the circumstances, and duly fined him a pretty tidy sum for saying it. Now, that obviously was a stupid example. It gets rather more serious when you have people on Twitter who say things that the trans lobby don't like. And a number of people there have found themselves arrested and taken away in front of their children by the police, and either fined large sums of money or told by the police, shut up, or you will find yourself taken away and put in prison, and we will confiscate all your computer equipment and so on. So, we have the same problem in a slightly different guise. And I was also struck, actually, by regulation without rulemaking. What's happened here is, it's taken place in a different way, but a lot of our public institutions have been taken over by pressure groups. And again, I'll give you simply one example, because this is something which 2 days ago, finally, we got rid of. We have an Equality and Human Rights Commission, and you can imagine what it is. Obviously, we're a unitary jurisdiction, so we don't have to worry about federalism and so on. But that had been taken over lock, stock and barrel by, firstly, left-wing university people, and secondly, Stonewall. Do you have Stonewall in the States? Right. They had taken it over and were, in essence, dictating what its views had to be on a whole lot of matters, and were saying, for example, you must always prefer equality and trans rights over freedom of speech, and things like that, despite the fact that the EHRC was meant to hold the ring between our various quasi-constitutional rights. I bring that up because, following pressure from the government, I think it was 2 or 3 days ago, our commission finally fired Stonewall, but Stonewall is also subscribed to by very large numbers, several hundred of our public authorities. And it's still quietly dictating quite a lot of their policies, including the policies of universities as regards education. Anyway, so that gives you a flavor of some of the things which I've been noticing here, which again reflect the same sort of processes as you have in the book, but in a different way. The reason is exactly the same. You have an elite. You have an elite which despises the common people. It went completely ape over Brexit and said, well, you know, you guys really don't know what you're talking about. You're a bunch of bigots, racists, knuckle draggers, people living in the 19th century. We knew better. It then, of course, attempted to prevent Brexit taking place. We were very lucky that it didn't. But it's still very much in charge. It spat when we had a by-election for one of our parliamentary constituencies last month, and the people actually insisted on voting for Boris Johnson, who hates them. What to do about it? Well, in the American context, I had one thought, but again, it's not really something I should say a great deal about, but I very much agree with John that you do need, I think, to go very, very much back to more state power, because states are, to some extent, much closer to individual voters. And certainly I would be very much a states' rights man in that particular respect. As regards Britain, I'm actually a little bit more sanguine. We obviously don't have a federal system. It is very much a matter of culture. And I think it's very much a matter of giving inspiration to the individual voters. We don't have constituencies gerrymandered and looking like roadkill, which, if I may say so, is very much a feature of many American states. And there is a chance, actually, that people now, especially that we've left the European Union, will begin to think for themselves and not think in terms of letting the elite get away with it. At least I cross my fingers that that's the case, but I'm more sanguine than I was. Anyway, I think I've spoken quite enough. It's probably time to throw everything open to general discussion.
Thank you, Andrew, and thank you all. I've made a lot of notes here, and I was thinking, my goodness, I wish we had more time to discuss all the profound things you've raised. If I may, I'm going to ask you a sort of political scientific analytical question. I'm the only political scientist here, and so my first utility to draw out of this book will be how I teach how I use it to teach my students. And the first thing that struck me was the schematic, or the typology, I think I should call it a typology, that Copland uses to describe the problem here, or the problem at the actor level. So there's 4 types of actor that Copland identifies as problematic. So he calls them the rule makers, the enforcers, the litigators, and the anti-federalists. And I'm going to find this very useful in teaching my students political science about the problems of American democracy at the moment. So the political scientific question is, which of these 4 actors does anybody think is most problematic here? I don't think Copland ranked these actors in any way as more problematic than the others. And in fact, rule makers, enforcers, litigators, they get sort of conflated in the administrative state because there are actors there who are unelected and they're acting as all of those things. But does anybody have a thought about which is most problematic on that list? And then that may give us some indicators of where we should focus our solutions. Anybody?
See, I think they're all, in some ways, equally bad in their own domains because of their, bedrock mentality of we know best. And as Professor Tenborn said, the common people are benighted and reactionary knuckle draggers, and we need to impose our superior expertise and vision on them. So I think they all partake of that point of view. They don't seem to have any compunction about overreach, about an expansive approach to whatever their responsibilities are. They, don't go into their activities with the spirit of liberty and the mistrust of concentrated power and the exercise of power, and they moralize their mission. And I think that's happening in all four of those sectors, frankly. And that's the problem.
I think that's a great question, Andrew, because I think it again highlights that the book, I think, needs a better theme. So when he describes what's wrong with all of these actors and the way our system has changed, he says it's because of a lack of accountability. Although the stories are all about how dumb their decisions are, which is different, right? That's a different. The examples he uses are, you could just say, are from a utilitarian basis, were just mistakes for human, social welfare, without regard to whether they were accountable or not. But then he says, right at the end of his book and in the beginning, he says the real problem is they're all unaccountable. If that were the case, then the most unaccountable in his list are the litigators, right? The judiciary is appointed to lifetime positions. We don't elect people who bring cases to court, and right, the decisions, if they're at the constitutional level, can't be reversed through the democratic process, or change takes 20, 30 years just by changing the judges on the courts. And this is the problem. But when I look at the book and the problems it sets out, it's not clear to me the litigators are one causing the most disruption. They're not the ones who are, all his stories are really more about the rule makers. I think the rule makers and enforcers are really about the executive branch and really the independent agencies. But they're not the ones who are the least accountable in the typology that you've just listed. It's the what Amy called the litigation state. They're the ones who are the most independent of democratic control.
Yeah, that's a good point, John. I think also there's a dimension Copland that runs through the book that Copland doesn't necessarily make explicit in his argument, and that is that he's not just complaining about the unaccountability. It's the power that is being wielded by these actors outside of the intention of the constitution writers themselves, such as state attorney generals interfering in national commerce, and national commerce is the key example that Copland dwells on. But attorney generals are interfering in all sorts of things, and that emboldens, or it creates a permissive environment for then proxy shareholder groupings to interfere in corporate affairs. So the intended constituted powers in America are upended. So now state officials, some of them are appointees, they're not even elected officials. They have power to interfere at the federal level, which was certainly not intended in the Constitution. So that's another dimension by which we can cut who is most problematic here. It's not just who's causing most trouble, that's one dimension. Who is least accountable, that's the second dimension. And who is wielding the most power outside the intent of the Constitution itself.
I don't want to be a big defender of the way litigation has turned up in our world, but I do think this common law system, which you British imposed on us and we have never escaped, actually is to me, oh, by the way, the author, right, he repeatedly cites Richard Epstein, my podcast buddy, but the theory of the common law as being this, vast decentralized decision-making system that tends towards efficiency, I buy that. I'd rather have the common law litigation system than, rule by enlightened bureaucrats or competition amongst state attorney generals to become elected governor or senator, and they'll bring the cases. Maybe it's a race to the bottom here, but so I quite agree. But of all those systems, and maybe I've been teaching in law school too long, litigation seems the better decision-making system than this sort of Wilsonian European style, bureaucracy and dictate from above by an elite.
Can I just say something? I'm all for the common law, and I think it's a great system. But I think there is, the litigation state is problematic at this point, but we can't entirely blame lawyers for it. I mean, I think, first of all, there are too many lawyers. I think size matters, quantity matters, and you have all of these lawyers looking for something to do and looking for, causes to advance. There's also an activist mindset that I think is particularly pernicious among the legal establishment and the law schools now that fuels all this. But, lawyers can only go so far as the system lets them go. So I think to blame lawyers and litigators directly is misplaced. What Copland documents, I think, very well is all of the rule changes and the kind of relaxation and the loosening that has worked together to enable all of this activist litigation, to enable all of these, the pile-on of lawsuits. I mean, all of that stuff is, I hate to use the word, systemic. The system is at fault, really. The lawyers are just doing, trying to make a buck, frankly.
Yes, all lawyers are actually slightly different in that respect, because unfortunately they've got into bed very much with our anti-federalists. Because we're now very much being run by political litigators. And it's not political litigators trying to enforce constitutional rights from the 18th century because we haven't got them. What you've got is increasingly everything to do with immigration, with climate change, with equality is being litigated. We have, I'm afraid, a judiciary which increasingly was brought up in the 1970s and 80s with radical university professors teaching it. And you can see the effect of it in what happened in Britain at the end of 2019 with the decision of our Supreme Court, which I'm sure you all read about, when our Supreme Court struck down the dissolution of the prorogation of Parliament. Now, if you read that decision, our Supreme Court essentially said, okay, there's no written constitution, but we have our ideas of constitutional virtue. It's our ideas of constitutional virtue that matter because we, after all, are the educated guys, or in this case, the educated gal, because it was Lady Hale who was absolutely at the forefront of this. Lady Hale is an object lesson in why not to put academics on the bench, incidentally. She started out as a law professor. Well, I say that as a law professor, I'd be quite the wrong guy to put on the bench.
Oh, no, I'm not outraged. I'm disappointed you didn't say it's an argument against the feminization of the bench.
I'd better keep a little bit quiet about that before I get lynched by somebody.
No, I endorse that argument, frankly.
Anyway, no, the Supreme Court said essentially it is now our job to act as the guardians of abstract constitutional virtue. And insofar as other people don't like what they've done, well, we're the educated guys, they aren't. And our word goes. It was an absolutely frightening decision. A few sensible people in this country said it was. Of course, the vast majority of academic law just said, oh, well, it's an obvious decision. You know, it logically flows from all its premises. It made depressing reading. But anyway, I must stop the rant.
Yeah, and I think that you draw out, Andrew, you draw out a couple of key differences between the British and US case. I mean, first of all, Britain does not have a written constitution. It has a constitution based on precedent, some of it medieval, and that creates more ambiguities and lack of clarity than the US, and we struggle with interpreting the US Constitution. It's even more difficult in the British case, and that allows the Supreme Court to be more proactive, activist. Activist is the right word. The other thing I wanted to draw on is the ease of litigation. So Copland spends a lot of time explaining how it came to be that the American tort system is peculiar in that it does not allow the defendant to recoup the costs of defending themselves against frivolous lawsuits. That's very peculiar. And Copland complains that makes litigation too easy, and that helps to explain why there is so much litigation in the United States. Now, he wants to fix that. He wants to make it less easy. So one easy way to do that is that you just say defendants can recoup the costs of defending themselves against a plaintiff's case, a plaintiff that loses their case. Now, I just want to point out on the British side, you have a tort system where you can claim costs, right? That's how it's phrased in British civil courts. You can claim the costs of a frivolous suit, or you can share the costs, so that the judge can adjudicate costs. Yeah. Now, the problem with that is it's actually very difficult. It's very burdensome. The correct word is burdensome. It's burdensome for plaintiffs to bring civil suits. If you're a big corporation, it's easy. But if you're a private citizen, you want to take a corporation to court, it's practically impossible unless you seek legal aid, which is a government-funded pool of money. But there's an adjudication process there where the people who give out this money have to decide whether you have a good case. So and that's open to politicization. So you need financial aid, or you need a sponsor. And class action suits are a lot more difficult in the British case too. So for me, as a dual citizen, having lived in both countries, I see the disadvantages of both systems, where it's very difficult to bring a case in Britain, and therefore a lot of organizations get away scot-free with malpractice. But I think, on the American side,
is right.
There's too much litigation, and then the legal costs are very high, and then that's passed on to the consumer, such as healthcare. One of the reasons healthcare in America is so costly is because of doctors having to insure themselves against very expensive litigation. So is there a way out of this balance, apart from saying the sort of platitude that you need a balance?
I don't think.
Well, can I explain how we do things? Actually, it's changed a little bit since the 1960s and 1970s. The basic rule is still loser pays, and I'd be a very strong supporter of loser pays. It's one of the very few things where I support the fact that every European country says the same thing. We have found a number of ways of mitigating it. One is this: we do now allow contingent fees. How does the plaintiff avoid being faced with an enormous tab if he loses? Well, we've evolved a system of what's called before the event or after the event insurance. So you can take out an insurance policy against having to pay the other guy's cost if you sue him and lose. And then, having taken out that policy, you can go in on a contingent fee basis. It's a little bit clunky, but it does give at least some advantages. The other thing that we do have, and I don't know how many people stateside realize this, is judges who are now very, very active in keeping down the lawyers' costs. If you bring a case in England, and the cases of any size whatever, basically you'll have a case conference and the judge will call everybody in, knock their heads together and say, right, sorry guys, I am not having 6 experts on either side. I don't care, you can both do with one expert, each side can do with one expert. I am not going to allow costs for more than 2 days or whatever it is in this case. And we now have in our civil procedure rules a specific obligation for the judge to intervene proactively to reduce the costs as much as he can. And my feeling is that that's been something of an improvement.
Can I just say something about this? I don't think there's an easy solution to, the alternatives of who bears costs, because there are tremendous downsides to both systems. I mean, you either end up hurting defendants or you end up hurting worthy plaintiffs, and it's difficult to strike the right balance. But I think one problem that Copland does allude to is that, the problem is not just a procedural one, it's a substantive one. There are too many causes of action. They're too expansive. They're too easy to bring. The products liability, strict liability movement just makes it far too easy to pick the pockets of many of these institutions and companies. This is all, of course, orchestrated by law professors who've decided that systemically it's a good idea to shift costs to these large entities. I mean, there's all this theoretical apparatus behind these developments. The whole civil rights establishment, the expansion of what discrimination means, and these lawsuits just, proliferating endlessly, the leniency with which discrimination is described and articulated, the whole Title IX phenomenon. I mean, there are just too many ways to sue other people and potentially succeed in the United States. So I really think a lot of that should be tightened up, and tightened up pretty significantly. But that requires revisions in the it means pulling in and circumscribing and restraining some of the substantive rights that are supposedly the glory of our system. I don't see them as the glory of our system in every case. And that's very hard to accomplish. It's a one-way ratchet.
I suppose implicit in what you're saying, Amy, but let me check if this is what you meant. None of the solutions in the British case that Andrew just articulated, those are procedural solutions, I think you're saying, that would be insufficient. They might be necessary to the solution, but they're insufficient to the solution. Is that what you're saying?
No, I think they're all clever solutions. I think there are, once again, this is a broader theme with Copland, there are procedural steps that one could take. I think mostly they're kind of nipping around the edges. Because in our system, if you're a defendant, you're sort of a sitting duck to be sued, and you will end up spending a lot of money on lawyers, whether you like it or not, unless you just settle out, which most of them do, in part because of the potential to run up bills. And we already, for example, have a lot of active case management in this country, and there's been a trend towards more active case management as a way to keep costs down. So some of this stuff is happening. I just see too many lawsuits in an absolute sense.
What we do have actually is there's another procedural measure which you can use, which is quite nice. It goes back to a very old institution of the common law known as the law of maintenance. We've now got a very salutary rule that anybody who bankrolls somebody else's litigation, if that guy loses, can be sent the bill for the other side's lawyers. That is actually highly effective. The other thing we have is that a lawyer who brings an obviously stupid case, we have an extremely effective thing called the wasted costs jurisdiction, under which the judge can simply slap that lawyer with absolutely everybody's legal costs. Now, I believe that exists in some American states. I can thoroughly recommend it. It's extremely good at keeping away the thoroughly undeserving claim aimed simply at extracting some money by way of nuisance value settlement.
Well, you know, in the United States, I don't know Britain well enough. I wish I knew more, but we have a massive public interest litigation establishment in this country. And it is just so extensive. And politically, I cannot see anything like these measures being, you know, implemented on a wide scale, because virtue resides in these so-called self-appointed public interest organizations, and to stick them with costs would be viewed as, you know, amoral and right wing.
Yes, I plead guilty to both.
Me too, but.
John, did we cut you off? Is there anything you wanted to add on the litigation front?
No, it's just again, it brings me back to whether this phenomenon, which I agree with the other panelists, is going on. I think Copland's book is descriptively correct. Is it really the big threat to self-governance compared to the other, the other problems? There's no doubt that litigation has exploded because of the civil rights movement and the public law litigation model that arose after that in the 60s in the United States, and now England and Europe have certainly, emulated it. But it seems to me the bigger problem is the independent agency and the rule makers. Like, I think if the government had kind of stayed the same, but we still had this litigation system, it could be controlled. For example, all these terrible malpractice lawsuits against doctor. Amy's the doctor, so she probably doesn't like these and knows them better than I do. But this overregulation of healthcare practice because of worry about safety and overprescribing tests and so on, preventative medicine because of the effect of malpractice suits. But that's always within the control of states and their legislatures. You could have, this is one of the solutions that's mentioned in the book, is competitive federalism hopefully could create a response to that, because some state legislatures will pass laws to override these decisions by state courts. And
I think malpractice is really not the problem that it used to be. I think precisely for the reasons that he details, that the states have taken control. They have put caps on damages. They have controlled punitive damages. You don't hear as much about it anymore because there have been measures implemented that have mitigated the excesses of malpractice. So.
Yeah.
It's not only in the States that's happened. One very good jurisdiction, actually, which makes it much more difficult to recover excessive sums in malpractice litigation, is Australia, which most of whose states have actually now enacted caps on damages and all sorts of other limitations on recovery. And of course, both Australia and England do have the advantage we don't admit punitive damages in negligence.
That helps. But it's really pain and suffering that got them.
With the ways around that too, we now have essentially an unofficial table of pain and suffering damages. Of course, we don't have the constitutional protection for jury trial, and we don't have civil juries to speak of. But basically, pain and suffering is according to a tariff.
Right.
Unless there's a very good reason to depart from it.
So John, that's a great segue to what I wanted to move on to next. So this is still kind of a political scientific question, but you can help me in terms of jurisprudence, perhaps. And that is this tension in the book, Copland's book, between state rights and state interference. So Copland's very concerned that states, attorneys generals and other officials should not be interfering in national commerce. That should be regulated by the federal government. But at the same time, he clearly wants to reassert state rights. So the federal government under the progressives, the administrative state at the federal level naturally takes rights and powers away from the states. So there's a tension here, what I call state rights and state interference at the national level. Is there a solution to that can be, is there a legalistic, is that the right term, or a jurisprudential solution to this?
I mean, you could, but it would, lawyers might think it was just politically driven. You're quite right. I mean, conservatives generally love federalism, except when it comes to punitive damages and tort liability, where they would prefer to have a national solution. I've always thought that, I agree though, I always thought that was a tension, or actually in fact contradictory. I mean, you could jurisprudentially find a solution. You can say that at some point when the application of the state common law to things in the tort area, for example, or even in contracts, has such a negative impact on interstate commerce, it eventually runs to kind of constitutional prohibition. It runs into Congress's right to set national, and you could see the court, this Supreme Court in particular, trying to reinvigorate, limit the ability of any one. For example, California right now is notorious for effectively regulating product nationwide just by saying you can't sell your product in the state of California, which is 1/6 or 1/7 of the national market for almost everything, unless you conform to California standards. And they've really struggled trying to figure out a way to control that. And they haven't successfully so far.
Yeah, I think it's interesting to me that Copland talks hardly at all about the struggle over nationwide injunctions, which has been a big issue. These local judges issuing injunctions that effectively apply everywhere that the defendant has any activities in all jurisdictions. And there are some subtleties, of course, to the disputes over that. But it's not immediately apparent how that sort of use or abuse can be curbed. I think that at bottom, the problem really is the nationalization of commerce, that if you have a company that is creating local problems, it's usually not a local company. It's sued in a particular place, but then whatever liability is imposed affects their activities, not necessarily formally, but informally everywhere, because they realize that they're vulnerable to being sued over and over and over again in different places. So that's the way that, local initiatives get leveraged in a widespread way. And I don't see any obvious way to limit that. Copland does address this problem of personal jurisdiction, of how there's been a relaxed and expansive approach to personal jurisdiction, allowing for forum shopping and allowing for people to bring their suits in different places. I don't know if there are any obvious solutions to that. What it comes down to is that these companies, these defendants, they operate in all 50 states.
Yeah. Well, look, I've got one more political scientific question for you, and then I think you three should think about what questions you might have for each other, particularly on the prescriptions or the solutions side here. This is sort of a prescriptive question. It's about delegation of powers, right? So Copland's really excellent, I think, at the descriptive challenge, particularly to a lay audience, describing the extent to which the federal government has delegated powers to unelected administrators of what we call the administrative state, and they are acting as the rule makers. So they're writing laws for themselves without Congress's approval. They are enforcing those rules, and they're effectively litigating those rules too. And they have an incentive here to litigate widely, because they take the fines that they levy fines that they then take as income. And that, as Copland points out, that bypasses Congress's power of the purse, because now these unelected agencies can fund themselves by writing rules that are very burdensome and practically impossible for constituents to avoid breaking. And then they break those rules, and then they can be fined, and then there's a revenue stream for these agencies involved. And for me as a political scientist, it's that part of the unelected state that alarms me most, that we're being ruled by people who are not accountable to the people as a whole. But when we came to the prescription side, as a lot of people have pointed out, there's some vagueness in the final chapter about how you solve that, because Copland is saying, you know, the times have changed. We clearly need an administrative state. We don't want politicians ignorant in medicine to be making decisions about the pandemic. But at the same time, Copland says he wants to restore the principle of non-delegation of executive powers. I didn't find, and you can correct me if I'm wrong, I didn't find a practical prescription about where that balance lies. Does anybody want to suggest a more tangible prescription solution to that particular problem?
Can I just say something about non-delegation? You know, the whole idea of whether there ever was a non-delegation doctrine is hotly contested. I mean, you really should know that. There's all sorts of law review articles now being written about how delegation was there from the first. It was accepted. There are instances from centuries back, et cetera, et cetera. So I don't know how fertile a ground that is for really trying to circumscribe the administrative state. I mean, you have people like Philip Hamburger who are very adamant anti-delegation people, but I'm not sure they win the day. So I think that the prescription has to be very pragmatic. And I think if it's going to, there's going to be a solution, it's got to be twofold. The first is Congress has to write laws that are much more specific, much more pointed. You know, they have to use much stricter language in the laws and that they write. They are not inclined to do that. They hate doing that because it means they're accountable and they have to answer for what they enact. And they love offloading responsibility. That's their stock in trade, and they can barely do anything at this point. So they're a paralyzed entity. So I don't think that's terribly practical, but it would be ideal. The second is the courts have to crack down. I mean, they've done exactly the opposite with the Chevron doctrine, with the Auer doctrine. They don't want responsibility either. I think the most telling comment in the whole book is, I think he quotes Justice Stevens saying, when I'm not sure what's going on with these laws and all this technical stuff, I just defer to the agency. I mean, it makes my life easier. Yes, they're making their lives easier. And so it's their unaccountability that makes it difficult. Once again, we go back to these first principles, you know, transparency, simplicity, restraint. Do we really need this law? Do we really need this rule? Do we really need this foray into this particular area? Or should we just leave it to the local governments and the people? I'm not prescribing that for everything, but I think that there's a lot of room for devolution to occur.
Yeah.
Yes, I can afford to be smug here, of course, because of our slightly different constitutional arrangements. Because we have lots of delegated legislation of exactly the same kind, where you leave an organization and say, right, just get on with it, guys. But the thing is, what we don't have is the big independent agencies. Any government department in England which passes delegated legislation or virtually anyone, is technically under the suzerainty of a minister. And that means that it's under democratic political control. Now, I said I can be smug about that, because far be it from me to say that the US should abandon the great regulatory agencies. But I'm afraid it is the presence of large numbers of entirely independent quasi-governmental organizations which give rise to the problem.
Good point.
Yeah,
We have one quasi-independent organization which does make itself a confounded nuisance and limits freedom of speech actually appallingly, which is a thing called the Office of Communications, Ofcom, which merrily goes and fines radio stations, TV stations, and others whenever they allow anybody on who, for example, says something which is offensive to the feminist movement, or who says something which is against the prevailing wisdom on COVID. So we have your problem, but we don't have it nearly so badly.
yeah. I think to clarify, Britain does have an awful lot of classic administrative state agencies, not just Ofcom. I mean, the organization which is most pertinent to the free speech problem is what used to be called the Association of Chief Police Officers, which is not accountable to government at all, but has delegated powers to interpret the law and to tell police how to enforce the law. And it's that body, the ACPO, which created this, what they call non-crime hate incidents, which allows police forces to collect a database on anybody who tweets something that anybody finds offensive, say offensive to trans people, and then police will log that as a non-crime hate speech, a hate incident, and it has implications for employment, because a lot of jobs require a background check from the police before you can be considered for the job. And one of the databases that is consulted is this non-crime hate incident database. And that hasn't passed through Parliament. It hasn't come out of the executive. It hasn't been scrutinized by the judiciary. It's just come out of this quango, classic quango, which is telling the police how to enforce the law that has not been, the law itself has not been interpreted by the place that legislated it in the first place. And we've got other examples of this. The PHCO, which is the Parliamentary and Health Services Ombudsman, which decides whether public healthcare, which is completely tax funded, has committed malpractice. So there are two problems with healthcare malpractice in Britain. One is that litigation is very difficult, or let's say more difficult for Britons to start up if they don't have the means to pay for it up front than it is for Americans. And then secondly, they are obliged, usually by the courts, to go through the Parliamentary Health and Services Ombudsman. It's still, by the way, it is still masculine in its title, even though the occupants have sometimes been female. And that agency, as Amy was articulating, has no incentive to investigate these cases. It doesn't want the work, and it's not accountable to Parliament, except very indirectly through its funding. So it just avoids work. And there are too many agencies like this, and the motivations are the same for the British government. They want to delegate their responsibilities. They don't want the work. And then the agencies themselves delegate responsibilities, or they avoid the work, and they're not accountable for it. So the parallels are very strong in my reading of British and American politics on this administrative state problem.
But they don't have the power actually to pass rules binding on you and me. They don't have the power to tell you and me what to do. I think that's the difference. And I agree, the Association of Chief Police Officers is a horror when it comes to non-crime hate incidents. And actually, with a bit of luck, the Court of Appeal will say they can't do it because we have litigation on that going on at the moment. But none of these organizations does have the power actually to issue rules, the breach of which can give rise technically to legal consequences.
Right. I mean, you're saying we don't have any regulators in the American sense.
We don't have regulators who are not under the control of a particular ministry, that is, of a particular cabinet member or whatever.
Yeah, I guess that's true. I'm still pushing back on you, Andrew, a little, because I think ministers, in theory, are directly accountable for their portfolios, but in practice, they will say, oh, you have to go through this quango, and of course they avoid responsibility that way. And a lot of quangos sort of regulate. I mean, think of it in healthcare. Think of NICE, right? The NICE is the institution which regulates prescription drugs. So it's the equivalent of the FDA. It does regulate, and it's supposed to be arm's length, as the British government calls it. So if NICE makes a problematic decision, the governments can say, well, you know, they're independent and that's a good thing and there's nothing we can do about it. So don't you I'm pushing back on you a bit, Andrew, but I mean, we do have regulators, right? Unaccountable regulators.
We do, but it's always open to people in Parliament to actually attack the minister on it, and he can't necessarily get away with saying, well, I left it up to NICE, if he's got a competent opposition. Now, admittedly, that's saying quite something in Britain at the moment, but if there is a competent opposition, they can actually say, well, wait a moment, you can, if necessary, do something about NICE. You can do something about these organizations. If necessary, you can change their composition. That was actually what was done about Equality and Human Rights Commission recently, which again is an arm's length agency. The relevant minister simply went and appointed 3 civilized people to be commissioners, and the result has been absolutely magic.
Yeah.
But that's something that would be very difficult in the States.
Yeah, I think I cut off Amy. Amy, were you trying to get in there?
Sorry.
No, you haven't cut me off.
All right.
No problem.
Right. So let me try to bring the Americans back in here. This is kind of a political question again. I mean, one of the prescriptions in British politics is that the people need more referenda. Referenda, popular national referenda, or actually state referenda, as the case may be, are ways to bypass the administrative state and to give power back to the people, which has been diluted by the rise of the administrative state. And that's in the British case, that's clearly been borne out by the Brexit vote. If there had not been a referendum, clearly the elite was moving in a completely different direction to the bulk of the populace, and we would still be in the European Union. So referenda are useful for bringing power back to the people, which has been removed by many things, but including the administrative state. Now, I should say, at the state level particularly, we already have a lot of referenda. So we call them propositions. So we still have direct democracy. We still have probably more direct democracy at the state level within the states than Britain does. But should we have more referenda as a way to solve this problem of the unelected making so many decisions?
Can I just address that? I think the quintessential example of that and where it worked was in the California referendum on affirmative action, and if in effect suspending color blindness, which took place recently, and John can probably talk a little more about that, and how the people overwhelmingly voted for an old-fashioned impartial standard and against abandoning that standard. And what's telling about that example really goes back to my theme, which is that we have, through the offices that Copland documents, an elite that is not representative of what most people think and believe, in control, and they control the litigation state, they control the administrative state. And to me, that is a pathology. I am not a believer in plebiscite government. I think a well-functioning republic shouldn't have it. And the main reason I think that is because the idea behind a good representative government is that you have wise, informed people who understand the issues and understand them better necessarily than ordinary individuals who are spending their time hopefully living their lives and not obsessed with politics and the niceties of the issues. And that, to me, is the way a republic should function. But we don't have that right now. We have the unelected in charge. We have a massive administrative state. We have all of these aberrations and all of these distortions and pathologies. And in that situation, I think there are uses for referenda. They reveal that what the leadership, the elite leadership wants, that class wants, and what most people want are out of sync. To me, that is what Trumpism revealed. And those 74+ million people are not going away. And if you put a number of the hot issues of the day, like immigration, or many civil rights questions, or a lot of economic questions surrounding climate change and pet causes and redistribution and reparations and all of that stuff to the people, many of the leadership wouldn't like the answers.
Of course, there is one grown-up republic which does this the whole time, and it's highly successful. Most of the referenda fail, and that's Switzerland.
Switzerland, yeah.
If you go to Switzerland early any summer, you will find there are probably 2 or 3 national referenda and probably 2 or 3 cantonal ones on, all at the same time. Most fail, but it's very, very salutary that government knows that if they can get, I think it's 100,000 people, but obviously in the States you'd need more, but if they can get 100,000 people to agitate, then there is a chance that they'll actually tell the government what to do, and there's nothing the government can do about it.
My thought is very much in line with Amy's and Andrew. Initially, I wouldn't support having direct democracy, but and it wasn't used that much in the beginning. It's been in the state constitution for a while. Pennsylvania, my other home state where Amy is, also has a kind of initiative process which was just used, but rarely used generally. But it's getting used more because the pathologies that Copland talks about in his book have been occurring, that the government has been kind of captured and is sort of farther and farther apart from the people. And so it's not a surprising reaction that the people trying to reassert control over the government through this one mechanism. But it's interesting. I think it's a very effective mechanism at the state level. I don't know whether I would want it to exist for the national government, though. That's maybe there, sort of the people delegating their power to a republic makes more sense than having direct democracy. But it would be an interesting experiment to see whether it would work at the national. But I think maybe, and Switzerland is very much like this. Smaller jurisdictions, I think, it can be very effective.
Well, of course, in Switzerland, it's not simply a plurality that decides national referenda. You've got to have majorities in a certain number of cantons as well. It does actually give enormous advantages to small cantons like Appenzell, Innerrhoden, and all the other ones you've never heard of. But I think it's a fairly successful system. My spies in Switzerland tell me that it is.
Well, if like in the United States, the smaller ones are more conservative, that's good.
Yep.
Yeah, and the smaller
on conservatives in Rhode Island.
Right. And
there are exceptions, Delaware. Obviously. But
right. And the smaller ones,
Montana.
like Rhode Island, they have inordinate power at primaries, for instance, and the rural states are overrepresented in the Senate through the Senate. So, I mean, there are ways to overrepresent smaller states in the American system too. Well, thank you, everybody. It's been a very stimulating discussion. I appreciate your expertise and your time. And thank you remotely to James Copland, who gave us the book to discuss and bring attention to this important topic. Thank you all.
Thanks.
Thank you.
Thank you.